140 words per minute for 9 minutes. 5 seconds more. Start. The applicant herein had filed a complaint under Section 138 of the Negotiable Instruments Act against respondent number 1, who is his friend. The applicant is a businessman dealing in the business of construction. Respondent number 1 had purchased cement and other hardware material from the applicant on credit. Respondent number 1 had therefore issued a check for Rs 1 lakh dated 20th December 2014 drawn on Punjab and Sindh Bank, Goa. On presentation of the said check, it was returned back with remarks, "No such account." Since the check was dishonoured, notice was issued on 29 January 2015, which was duly received by respondent number 1 on 30th January 2015. The applicant therefore filed a complaint under Section 138 of the Negotiable Instruments Act before the learned JMFC. The respondent appeared in August 2016 and sought time to furnish surety. The case was adjourned for 17 September 2016. The respondent number 1 thereafter appeared and furnished surety. He pleaded not guilty and therefore the case was fixed for trial on 14th October 2016. On 3rd November 2016, the applicant was present before the learned magistrate and sought time to file affidavit in lieu of evidence. The case was adjourned for taking steps on 17th November 2016. On the said date, the applicant sought exemption and time to file affidavit in evidence, which was granted, and the matter was adjourned to 30th November 2016. The applicant filed an affidavit in lieu of evidence on 30th November 2016 and its copy was given to respondent number 1. The matter therefore was adjourned to 28th December 2016. On 28th December 2016, the applicant could not remain present on account of his difficulty, which was duly considered by the learned magistrate, who granted a last chance to the applicant and adjourned the matter to 19th January 2017. On 19th January 2017, since the mother of the applicant had a fall from bed at her residence, the applicant had to carry her to Goa Medical College for treatment as she was unconscious. On the same day, the applicant informed his advocate that he could not remain present in the court due to illness of his mother. His advocate promised him to do the needful in the court by mentioning the matter. Since the applicant remained busy with his mother, he could not contact his advocate and ultimately his advocate informed him that the learned magistrate has dismissed the complaint on 2nd February 2017. The advocate of the applicant informed him that he could not remain present in the court when the matter was called. The applicant therefore submits that he was under a bona fide impression that his advocate would attend the matter on 19th January 2017, as he had already informed his advocate about his inability to attend the court on that date due to the hospitalization of his mother. It was the duty of the advocate to remain present or to make some arrangement, which he did not do, and therefore the complaint came to be dismissed by the learned magistrate. As such, it is submitted that the applicant could not remain present only on 19th January 2017 and 2nd February 2017, which was neither intentional nor deliberate, and therefore he should not be made to suffer on account of failure on the part of his advocate to remain present in the court for hearings. I have heard the learned counsel appearing for the applicant, who argued in support of his application by reiterating that absence of the applicant was bona fide and therefore interest of justice would be subserved if the impugned order of dismissal of the complaint is set aside and the matter is restored to the file of the trial court for decision on merits. According to the learned counsel, despite intimating by the applicant to his lawyer, he did not appear, for which he should not suffer. Per contra, learned counsel for respondent number 1 submits that it was a willful absence of the applicant who was aware about the last chance granted to him. It is also submitted that there is no medical proof on record to show that the applicant's mother was ill. If the appeal is allowed, it would cause prejudice to respondent number 1. It is well settled by a catena of decisions that doctrine of audi, alteram, partem contemplates that no one should be condemned unheard. It is also held in number of decisions that a party should not be allowed to suffer because of a negligence of his counsel. The learned counsel appearing for respondent number 1 has not challenged the contention of the applicant that the complaint came to be dismissed due to the communication gap, or rather negligence of the advocate appearing for the applicant in the trial court, as is evident from the copy of roznama filed on record. It appears that the applicant was diligent enough to inform the counsel on 19th January 2017 as regards his inability to attend the court on account of illness of his mother, who was required to be admitted in Goa Medical College as she became unconscious due to a fall from the bed. The roznama dated 2nd February 2017 also confirms the fact that the advocate for the complainant was also absent. The learned magistrate therefore proceeded under section 256 of Code of Criminal Procedure and dismissed the complaint, which has resulted in acquittal of the accused. It is pertinent to note that the complainant had already filed an affidavit in lieu of evidence, and the matter was posted probably for recording the evidence and cross-examination of the complainant. If the impugned order is allowed to hold ground without any fault on the part of the applicant complainant, he would indeed feel prejudice as regards his valuable rights. The learned counsel for the applicant has therefore rightly placed a useful reliance on a case law of this court, and has also placed reliance on other cases. In all these cases cited, the complaint was dismissed by the learned magistrate due to absence of the complainant. It is held that principles of natural justice are required to be followed by giving an opportunity to the complainant to prosecute the complaint on merits, as well as an opportunity is to be given to the accused to contest the complaint on merits. Therefore, the matters were restored by setting aside the impugned orders. The disposal of the complaint herein filed by the applicant under section 138 of Negotiable Instruments Act, resulting into acquittal of the respondent, was due to absence of the complainant and his advocate on that date, and as such the said dismissal of the complaint was on technical grounds and not on merits. Vital rights of the complainant are involved in the said complaint, since apparently there was a transaction between the complainant and the accused in respect of check of rupees 1 lakh, which is involved in the matter, and therefore an opportunity is required to be given to the complainant to prosecute his complaint on merits. In the light of the aforesaid discussion of facts and taking into consideration the ratio laid down by this court in the authorities cited, the following order is passed. The appeal is allowed. The impugned order passed by the learned magistrate is hereby quashed and set aside, and the criminal complaint is restored to its original stage. The parties shall appear before the trial court on 12th October 2017 at 11 am. The learned JMFC is directed to proceed with the matter as per law. Criminal miscellaneous application is hereby disposed of accordingly.